So I guess asking this question in a different way. Say a student, two different cases of the same thing. So a student creates something that is, like, could be patentable, or that is patentable, say.
Say is patentable, yeah. Well, again, that's hard to know. Okay, let's assume.
But
yeah.
say they've done the research that they know that is patentable.
Okay.
Case one, they go off themselves trying to go through that process of patenting it.
Right.
So I guess in the policy that would be things that are, I guess, past tense commercially, substantial commercial value.
Well, if they've graduated, it's of no relevance.
If they're still in school and it's something
if they're still in school, it's highly unlikely that any individual student here, unless they're very wealthy to begin with, and I think since I've been here, there have been 3 really wealthy students in the school. I mean, really wealthy. We're talking multi-millionaires. So that's over 14 years. So I think we're pretty much clear that there aren't that many wealthy students who come to the school. So if they're really wealthy and they're capable of looking with a lawyer, patent law, how it might how much it might cost with respect to what they're pursuing. That's one thing, and they're probably, most of the time what we are asked is, can you help us pay for a patent lawyer? That, if in fact it occurs, right? So the student comes and says, and we say, well, do you know what that actually means? That's a lot of money. And then of course everybody, you've got to remember, there is a sense, artists are funny that way, there's a sense that it's like a lottery. There's this kind of myth that, I'm going to invent this thing and win this $1 million. It's like really weird. So a lot of the time, it's unrealistic, most of the time, which is not to dampen it, but it's just to say it's most of the time it's unrealistic, and most of the time what somebody thinks is patentable isn't. So there actually is benefit in talking to the institution that way in terms of what it can provide from an experiential point of view and prevent you from going off and spending money that you may not want to spend and may not be able to. On the other side, if you're going to if you're in 3rd year and you feel you've invented something amazing and you find a patent lawyer who would do you well, and there are many bad ones around, and you actually get something done that's patented, you're doing this and nobody knows about it, and you've suddenly got this amazing invention, and suddenly the world changes. You're probably going to end up in some sort of discussion, but even then, as any good lawyer knows, that discussion probably won't produce the outcome. You know what I mean? Like, so these are areas of very, very, there's such specific examples. The students who invented the algorithms that make the BlackBerry work never actually, were charged, so to speak, by the University of Waterloo. They've since given back much money in donation and so forth. But the discussions were always present, but not to the extent that they produced that direct outcome. The only way things work in a linear fashion in this world, very complex world, is that everything is started from the beginning like a narrative. So you start, and you say, I'm going to invent this. We say something's going to happen. You do it, then we say something else is going to happen. It's really hard to do it back and forth because proof can't be provided.
The linearity point is really, I think, also critical to understand, which is that it's sort of like the example of Logorama. Right. We watched that together, and as you all know, that was a group of animators in France that made this film. They didn't seek any advice from anyone. They didn't engage with any of the trademark holders in order to create that, and it basically went viral. Right. It was a distinctly non-linear process. And when David says, at this point, it would be foolishness for any of the trademark holders to come after them, in part because of that lack of linearity. And this is also the downside of being too slavishly attached to the idea of permission. And you've heard Lawrence Sussex speak about this, and you probably have heard this at other points in the course, about the feeling that we shouldn't be having to ask for permission, and there is a tendency to be a little too far in that direction, because when you do that, you are kind of going the linear route, which is the first step, is to get the permission. Actually, and I think I've said this several times, the first step is to create the work. The second step is to, as you do it, to do it mindful of the borrowing that you're doing and not be foolish about it. There are ways of managing your use of imagery to minimize the impact. And then, when necessary, yes, attribute and, where possible, get the permission. Understanding that there may be certain uses that you're not going to get the permission for, like Arvo Part's music, like Beckett's plays, like, the few examples that we've talked about. But the linearity, I think, is the legal world is very linear, and it makes us think that we have to do things in this very linear way. Whereas what I think we've been talking about for the last however many weeks is basically the grayness, the lack of linearity, and the need for you all to know enough to manage that environment.
So that was a question. Go ahead.
Sort of in terms of the Mitsubishi situation, is there any way the university can sort of do anything about that kind of situation? Like, is there any way the university or the institute could prove that it was created on the here, or go after the company and say that was, is there any kind of protection?
Yes,
that
there was at a certain point, not now, but there was at a certain point some possibility of that, but the cost of that was so high, and the return may not, because again, sure, this person dropped by, saw a design. I mean, there's the famous case with Steve Jobs from Apple having dropped by Xerox PARC and noticed, them playing around with something that looked like a mouse, and then, suddenly Apple, not immediately, but 3 or 4 years later, has a mouse. Those things are very subtle. And so the capacity to engage in a real back and forth that would be productive is not there, I think. I think the issue, the issue is kind of, it's kind of like to assume from the start that there are dangers, so then there are. But I think you're ironically in an institution where that danger is probably less than it would be in other institutions. And it's not because of my presence in it, because I'm open source, I borrow and I beg. It's nothing to do with me personally. It has to do with the culture of the institution itself, its history, which I think has always promoted a very profoundly felt sense of consensus around lack of censorship, not worrying too much about copyright. We have examples of people going. The best example of a copyright infringement is our own library. We have 125,000 slides of artwork, but 95,000 of those slides have absolutely no copyrightable trace, no permission.